The 2012-2013 Medical Dental Legal Update continues with Protecting Your Personal and Professional Assets, a primer, featuring David B. Mandell, JD, MBA. Mr. Mandell of Fort Lauderdale, Florida, is an attorney and a principal of the financial consulting firm Odell, Jarvis & Mandell, LLC, where he specializes in risk management, asset protection, and financial planning. He has authored a number of books, including The Doctor's Wealth Protection Guide, endorsed by 5 state medical societies. Mr. Mandell is a frequent national speaker, and his articles have appeared in over 100 publications, including over 30 medical specialty journals. You may contact Mr. Mandell with your questions and comments at 877-656-4362 or by email at mandell@ojmgroup.com.
Hi, I'm David Mandell, and today we're going to learn about asset protection, both on the personal level and on the practice level. And I'm excited to teach you about that today. But before we begin, a quick note, which is don't try this at home without proper guidance. What I'm going to be telling you about has a lot of legal implications, legal tools, tax implications, and as I hope you'll see, some real tax benefits to some of the tools. Certainly insurance and financial issues as well. So what I'm trying to do today is give you some real solid ideas that you can bring home and that you can either talk with your local advisors about, contact us about, learn more about, and see if it applies to your personal situation, your practice. One of the things that I've really enjoyed about speaking at the AEI over the years is a lot of the attendees have contacted us, and one of the things you'll see in the bio and in my introduction, I've been writing books on these topics for many years. In fact, in 1997, I wrote the first book for physicians on asset protection planning called The Doctor's Asset Protection Guide. It was a hardcover book, and we had probably about 500 physicians who got that book in the first year in 1997. Well, over the last now 16 years, about 30,000 of our books are out there. And certainly one of the things I like about working with the AEI is physicians like you are interested in these topics and want to learn more. And we're able to offer to you as an attendee a free copy of our latest book for doctors only. And I encourage you to contact us through the form, let the people know at AEI, and we'd be happy to get you that. In fact, being modern now in 2013, we have both the hard copy version and also a ebook version, and even a shorter, for those of you like the Reader's Digest version of the top ideas, a 50-page special report that's based on the book. So if you like some of the things, if you're intrigued by what you've learned today and you want to learn more, I encourage you to take advantage of that. So if you're interested in getting the book, our website is www.ojmgroup.com. www.ojmgroup.com, and there's an order form right on the book, right on the website. And if you mention that you're from AEI, it's all free. We'll send you out a copy of the book. You can indicate if you want the hard copy, or the ebook version, or the condensed Reader's Digest special report. Be happy to get that out to you. Now today we're going to be talking about our 5 different topics. First, I want to address common myths about asset protection. What a lot of physicians, like some of you, may think about the term and how important it is, and I'll try to address those and dispel some of those myths. Secondly, we're going to talk about the underpinnings of asset protection, what we call the sliding scale. Very important because throughout my lecture and in the book, I use this sliding scale, so it's important to understand that from the beginning. Then we're going to talk about practice protection, which is looking at the different assets of the practice, including accounts receivable, which is the number one asset for most medical practices, equipment, real estate as well. Then we'll look at cash flow, which is probably the most important asset to the physician, which is how to protect cash flow. And that's actually an area where we can see a lot of potential tax benefits. So I know tax planning is always important to our clients, and I'm sure to you in the audience. And then finally, we'll look at asset protection on the personal side, looking at protecting a physician's personal assets like a home, investment portfolio, other real estate, et cetera. And we'll look at all of those, and then we'll wrap up. First, let's talk about the common myths of asset protection. The first one is one I hear all the time, which is, how likely is it really for physicians to lose an asset in a lawsuit? Seems like it doesn't happen often, if at all, and so is asset protection really important? My answer to that is really a balanced one, which is if you read our books, the more you hear me speak, I'm not someone who pushes the panic button and says, hey, this is something you need to be losing sleep about, you need to go home and do this right away. As you'll see, I think asset protection is really important because there are other benefits as well, oftentimes wealth creation, tax planning, et cetera. But I think anyone who works hard and is trying to build wealth and save what they've earned should look at asset protection as part of their overall plan at both the practice and personally. And certainly physicians work as hard as anyone, and so to ignore it, I think, is unwise. In terms of how often do physicians lose assets to a lawsuit, it's hard to get that data. Certainly, if you look at what lawyers call reports of judgments, basically, in the local legal reporters, there are periodically judgments in the malpractice area, in employee issues like wrongful termination, sexual harassment, et cetera, that go beyond coverage limits. So a typical physician will have 1 million, 3 million coverage. There are oftentimes throughout a year cases that you'll see in any jurisdiction where the judgments are in excess of $3 million. So what does that mean? Does that mean that the plaintiff's attorney settled just for the insurance and walked away? Or did they go beyond that? And one thing I can tell you as an attorney is it would be legally unethical of the attorney representing the plaintiff to walk away or counsel their client to simply walk away from an excess judgment. If they had a judgment, let's say, for $4 million and the coverage was $3 million, that additional $1 million is something that the court determined that plaintiff is owed. And just to say, well, we're going to walk away because we don't want to go after the physician's personal assets is not something I think that would be tolerated by the client, and actually they'd be right to do that. So it's certainly not something that happens often. But you don't want to be one of the cases that does happen. And I have a story from my practice when I was practicing law in New York where there was an attorney who came to me, plastic surgeon, wife was an OB/GYN. And I showed him, did an analysis, had a bunch of recommendations, and they decided not to do anything. 3 years later, I hear back from them. Unfortunately, the spouse had a terrible case that happens. Life happens with one of the patients. And they had actually a $3 million judgment against them, but they only had $2 million of coverage. And now they were coming to me to say, hey, how can we protect these assets? And one of the important things to learn today is that you have to put this planning in place before there's a problem. Once you wait till you are sued, once you wait till you think you might be sued because there's a bad event with a patient or something with an employee, it's too late. So I think asset protection is important, and as you'll see, it doesn't have to be expensive. In fact, it can actually help you create wealth. Another common myth is that, hey, I have a corporation, I have a professional corporation or a professional association, a PA, or in some states a PLLC, a professional limited liability company. And since I have one of those entities, I'm protected, aren't I? And the answer is, as most attorneys would tell you, sometimes. A professional entity, whether it's a corporation, PA, or PLLC, never protects you, or me, as a professional, from our own actions or inactions. So if I have a problem with a client, if you have an issue with a patient, like a medical malpractice, the corporation will never protect you. That's why you have malpractice insurance. That's why asset protection planning is important. Where a corporation, LLC, PA can protect you is where you're not involved in the event that creates the liability. For example, let's say you have an employee go out and buy lunch. and they have to drive and go pick up the lunch, and on their way back to the office, they get into a car accident. You weren't in the car, you weren't supervising or involved in any decision-making regarding the driving. They were driving in furtherance of the practice, which is the corporation or LLC. So that is the entity that might have liability, but your personal assets, your personal liability would be protected from that type of situation. So when you have employees, PAs, PLLCs, PCs are very important because you want to have that level of protection for some actions that they might do. And there are tax benefits to having those entities in place, but they'll never protect you from your own actions, whether you're an attorney, whether you're a financial professional, or whether you're a physician. Okay? Another common myth is, well, I don't really need asset protection because I just put all my assets in my spouse's name. Generally, as you'll see in the sliding scale in another slide or two, I consider that pretty low in the asset protection tool bag. And the reason I do is it's something in the law called substance over form. And if all you're doing is changing the form, the substance is really what matters. So if you're the one of the two spouses earning most of the money, if you're the one who creates the liability, just by putting it in the spouse's name doesn't mean that you're going to prevent it from liability. Now, some of this depends on the state. For example, we wrote a book with 5 attorneys in the state of Ohio just for physicians in Ohio. And for some of you in the audience, we have specific state books in California, in Ohio, in New York, and Georgia. So if you're from any of those states, when you get to the website, you can make sure you request that book. But in Ohio, the attorneys all agreed, and we had 5 lawyers who all agreed on this. So that's pretty rare to get 5 attorneys to agree on anything. But they agreed that you could, in Ohio, under Ohio law, put the asset in the spouse's name, like a home, and still protect it from your creditors. Okay? Obviously, it's 100% vulnerable to their creditors, the spouse. So if they're a physician or they have liability, they get into a car accident, no protection there. But in a typical situation, let's say you have a physician as one spouse and the other spouse doesn't have that kind of liability, that would work in Ohio. What they also said was that even if they got divorced, that asset would still be considered a joint asset for purposes of divorce. That's not true in many states. So if you make that transfer to the spouse and then you get divorced, which if you look at the statistics for anybody, and certainly for physicians, it's much higher than losing an asset in a lawsuit. In some states, if you make that transfer and then you get divorced, you've lost that asset. So you don't want to protect an asset from one less likely creditor and leave it for vulnerable to an even more likely claim. So in most states, there's better ways to protect assets than owning in the spouse's name, and in a lot of states, it doesn't do anything whatsoever. The final myth I want to talk about before we jump into some tools that really do work is the idea that asset protection can only be done by attorneys, and it's very expensive. That's why I don't do it. I don't want to go to lawyers, and I don't want to pay a lot of money and to do this. And that's not so. As you'll see as we go through the tool bag, there are a number of tools, things like limited partnerships, limited liability companies, trusts, that are the jurisdiction, if you want to use a legal word, of attorneys. So attorneys do that. When I was practicing law every day, I used to create hundreds of these a year. However, you'll also see in the sliding scale that some of these tools that have the highest level of protection are not legal tools. They could be a home in a state that has high homestead laws. It could be a qualified retirement plan. It could be an annuity or life insurance policy. So the right asset protection plan is really, for most physicians, a combination of legal tools and benefit plans, insurance tools, potentially the use of debt, an entire range of different tools. And the good news about that is that for a lot of clients, it doesn't have to be very expensive. Maybe we use the attorney for 1 or 2 tools that are important as part of the plan, but some of the other strategies not only will not be expensive, but they may actually net save you money by reducing your taxes. So what I tell clients is, think about your net worth, think about your earnings and how much you're going to build over your career. What percentage would you spend to protect that? What percentage would you spend of the practice revenue to protect the practice assets? If it's anywhere around 1% or anything like 0.5%, you're probably going to be surprised that the planning that gets recommended is actually less than that in cost and actually maybe more than that in terms of tax savings. So overall, I counsel clients not to stay away from this because they think they've already gotten it from by putting assets in the spouse's name, by having a corporation. Don't stay away from it because they think it's going to be expensive, but actually dig in and look into what does it really mean for their practice, what does it really mean for them personally, and I think what you'll see is that a lot of the myths that I just laid out and some others don't apply. And I look forward to sharing some of the things and show you how they don't apply in the next couple slides. So now let's talk about the sliding scale. I came up with the idea of the sliding scale for asset protection probably about 12 years ago. It was in one of our early books. And my point in coming up with this was try to get physicians to understand that asset protection is not a black and white endeavor. Okay? You don't say, am I protected or not? That's not the right question. It's no more relevant than a patient asking you, am I healthy or not? Okay? Everybody's got some health issues, right? Obviously, we'd rather have less than more. And the same thing on asset protection. It's a sliding scale, and I use -5 to +5. -5 being an asset that has no protection whatsoever. If I had a judgment someone had a judgment against me, and I have an asset in a -5 position, they could put a lien on that asset tomorrow. They could levy that bank account and actually take it tomorrow. Okay? No protection whatsoever there. On the other side of the scale is +5. These are assets that have total protection. I could even file for a Chapter 7 bankruptcy, get rid of all of my creditors, and keep the asset in full. So a lot of people have asked me over the years, this is more relevant probably 15 years ago, but still people can remember, O.J. Simpson was somebody who had the criminal case and then had a civil case, and everybody knew in the country that he had a $28 million wrongful death judgment against him. And people used to ask me when those cases were relevant, how can he still live well? How does he still have money if there's a judgment against him? People saw that and it was very famous. Because of asset protection. No, he wasn't a client of mine. I went to UCLA Law School. I would never represent someone who went to USC. But aside from that, you need to realize that there are different tools that protect assets in different ways. And the +5 assets, you could have a judgment against you of any number, $1 billion. And if that asset is at the +5 level, exempt from creditors either by federal law or by state law, it can't be touched. Okay? In between the +5 and the -5 are tools that have some rights for creditors but make it difficult, have some hurdles that make it either expensive or time-consuming or almost discourage the lawsuit because the tools are very strong. And that's where attorneys play a very important role. Tools like, as you'll see in the chart here, limited partnerships, limited liability companies, certain types of trusts, basically bridge the gap between having the negative forms of ownership, which is owning it in your own name, owning it in a spouse's name, in some states, in some forms, owning it in a joint name. Consider that kind of -3, where half of it is potentially vulnerable if I own something with my spouse. In certain states, my half might be vulnerable to my creditors, her half to her creditors, but the whole thing is not vulnerable to either. I don't consider that a great level of protection, kind of -3, because you're still got a lot of the liability on both sides. In the middle of the scale, the 0, the +1, the +2, tools like limited partnerships, limited liability companies, and the subtleties are where are those set up? Some states are better than others. How many owners does it have? What's the purpose of it and all that? And then you've got certain types of trusts we'll talk about as well that, again, bridge the gap between the negative areas and the exempt assets that are truly off the table. So when you think about asset protection, you have to take it asset by asset and say, where does this asset, whether it's the practice accounts receivable or my home, where does it fall on the sliding scale today? And then what are the tools to try to move it up the scale into the positive areas? You're not going to get to +5 across the board with every single asset. That's unrealistic. In some states that have very strong exemption laws, like Florida or Texas, you can get pretty well protected in terms of your net worth in the +5. The practice, not so much, but certainly the goal would be to get out of the negative categories and move into the positive categories. And that's something every physician in every state can achieve without a lot of difficulty. The other thing that's important to realize is the rule, we have a chapter on this in the book, that the best asset protection is not asset protection. And what do I mean by that? It's kind of like tax planning. If you talk to any tax attorney, you'll realize that tools that have the greatest tax benefits typically must have other benefits to it. If you were going to do something that had no economic purpose other than tax planning, the IRS is going to have a pretty good argument to challenge that, because you would never have done it unless you did unless you had the tax benefits. So the same thing goes with asset protection. You want to have other benefits to it as well as asset protection. That could be tax, that could be financial, et cetera. And you'll see as we go through these tools some of the other benefits that are in the most important asset protection tools. So let's jump in and start talking about practice asset protection. Let's look at that. If you look at this slide here, you'll see that I say this is the worst way to set up a medical practice. And it's not just a medical practice, could be a law practice, could be a financial business, et cetera, which is something we learned back in second grade. Don't put all of our eggs in one basket. As I talked about before, whether you have a PA, a PLLC, or a PC, that entity can be helpful in protecting you from claims that you're not involved in, but never protects you from claims, again, from your own actions. But what about the assets of the practice? If you look at this type of corporate structure, any liability for the practice, and the practice will be sued and have liability whether you're involved or not. So that example I explained before, where the, say, receptionist goes and buys lunch. If there's a car accident, the practice will be the defendant in that lawsuit. If there's a sexual harassment case by one of the physicians, that case will come against not only the practice, but the physician as well. And even a malpractice action, if you've ever been through one, they name the practice as a defendant. So when we're talking about the practice, not about you, we have to look at protecting the practice assets. And if you have a one entity structure, you're putting all of your eggs in one basket. On the liability side, you're having malpractice there. You have wrongful termination employee type claims where the employee might be suing you. You have employee outward type claims, like the car accident where an employee causes a problem. So you have all those types of liability, and yet you have one entity that puts all of your eggs, your assets, inside that same entity. Your accounts receivable, your valuable equipment. In some cases with medical practice, I've seen real estate inside of the main practice entity. Typically, physicians get the right advice on real estate. Most practices that I see, if they own real estate, they keep it outside in typically a limited liability company and then lease it back, as we'll talk about, and you'll see in a slide in a second, to the practice. But you can use that concept of using multiple entities beyond just the real estate. That's probably the number one thing at the practice level that I see lacking in medical practice planning across the country. They do it right with real estate generally, not always, but generally it's done right for real estate, but for some reason they ignore all the other assets, like the equipment, like the accounts receivable. You can use the exact same strategy, and let's look at that. So in this slide we see the concept of a medical practice with multiple entities. And there are some real tax reasons, in fact I've covered on past AEI talks, on why to do that. We don't have time today to go through all the tax benefits, but you can just trust me and when I say that if you have multiple entities, you can take advantage of different types of tax treatments. So you could have, like I have with my business, an S corporation, a C corporation, an entity tax as a partnership, and all of those create different tax benefits for me in my case, and possibly could be for you. So when I mentioned before, asset protection often can be a very good way to get into some tax saving concepts. That's what I'm talking about. I'll bring some other examples up later in the talk. But if you have multiple entities, you can have a whole level of tax savings that you don't have if you only choose one entity. Okay? But from an asset protection point of view, you're also doing the opposite of putting all your eggs in one basket. You can have employees in different entities. So you could have management type employees, not ones that are billed on, not nurses, not physician assistants, but your receptionist, your billing and coding people. Keep them in a separate type management entity. If there's ever an issue with them, again, back to the example of the car accident with the receptionist, then no longer are they employed by the practice, they're employed by the management entity. So there is no claim against the practice. You've isolated that. Okay? The same thing if they have a claim in terms of employee issue, wrongful termination. Who is their employer? the management company, not the practice, so their claim is there. Okay, my business has 2 owners. We have 5 different entities, okay? Mostly actually for the tax benefits, not for the asset protection benefits. That was our main motivation. The asset protection is certainly very important to me as well, but I get both. I don't have to choose. They both come, and you could take advantage of that as well. In terms of the multiple entities beyond employees and cash flow and tax benefits, you can also use the concept to protect particular assets in the practice. I mentioned real estate. Very common. Any of you sitting in the room or colleagues you know who have real estate as part of their practice, most of the time, it's in a separate LLC and then leased back. If you don't have that, if you're sitting there and saying, oh no, my practice asset of real estate is in my practice, you need to work on that right away. You need to mark that down because that's not something that should be happening. You can do the same thing with accounts receivable. And accounts receivable for most medical practices are the #1 asset of the practice. I've worked with large practices that have $5, $10, $25 million of receivables at any one time. And obviously, the larger the practice, the more physicians, the more receivables you have because insurance companies and Medicare take a while to pay you. So why would you focus so hard on protecting something like the real estate while leaving the main asset of the practice that is actually turns into cash the quickest, the accounts receivable, unprotected? And there's been a lot of techniques that have come along in the last 15 years to protect accounts receivable. The one I like the best is what we call AR segregation. And we work with a couple of attorneys around the country who are particularly expert in this, who've done this for clients as small as 1 physician, solo practice, for as large as 100 physicians and $25 million of receivables. And the concept, again, is just like what many physicians are already doing with their real estate. Separate it and lease it back. If you think about separating real estate and leasing it back, it's a lease. We all understand that. You lease it back, the main practice signs a lease. With accounts receivable, it's a little more complicated to keep it tax neutral. It actually usually has to be a 2-step process where the accounts receivable are assigned to the physician who earned them and then create a separate LLC for that level of receivables. So if you had 5 physicians, you might have 5 LLCs, each one housing the receivables of the physician. This is not the practice of medicine. This is just simply the holding of the financial asset of the receivables. So you need then an agreement back to the practice. And what the attorneys typically do is create what's called a billing and collection agreement. Think of that as the real estate lease. That gives the rights back to the practice that unless there is an event of duress, okay, a legal term meaning a significant lawsuit against the practice or a judgment against the practice, or however you want to define it with you and the attorney, then essentially that billing collection agreement keeps everything the same. What I mean by that is just like if you're in a real estate, and your practice is in the real estate, and you set up a separate LLC today, and you have a lease back tomorrow. Tomorrow you come to the office, you're still using it. You may have that that lease be a triple net lease where the practice is still paying the mortgage, still paying the property taxes, still paying the maintenance. So for all intents and purposes, it seems like nothing's really changed. You're still there. You're still writing a check for the property taxes every month or every year or the maintenance, what have you. And so the only thing that really has changed is the underlying ownership of that real estate. Same thing with the receivables in the billing and collection agreement. Today, your billers and coders use a certain procedure to collect on the dollars. The bank account of the practice is the one that collects the dollars. After the LLCs are set up in the accounts receivable there, with the billing and collection agreement back, the same thing happens. So tomorrow, same people are making the same phone calls, the money's flowing the same way. But the underlying ownership of that financial asset is now in this LLC or series of LLCs. So think of it like a safety valve. If nothing ever happens, if there never is that event of duress, nothing changes. But in case there is that significant event, you've got that asset owned in outside LLCs just like you would with real estate. So now let's turn to actually real estate. And we've been talking about it for the last couple of minutes, so this slide isn't very surprising. You can also use it with equipment, probably one of the other high value assets in a medical practice. You don't have to have the equipment owned by the practice. It can be owned by a separate LLC and then lease it back. With equipment, there is typically a tax analysis that needs to be done. And I'm not talking about a memo. I'm talking about talking with the CPA, whoever your tax advisor is, because certain states or even cities have a lease tax or some hidden trap that you don't want to get caught in by just transferring the MRIs and then leasing it back. We always want this to be tax neutral or tax beneficial. So if you think about it, all of these concepts are the same. Real estate, equipment, accounts receivable. Separate the ownership into other entities, typically limited liability companies, and lease them back. And what I find, as I said before, is that most medical practices do it for the real estate. Very few do it for the equipment, but some. And almost none do it for the accounts receivable, which is kind of counterintuitive because accounts receivable are typically the most valuable asset of the practice. And certainly over time, if you think about the constant collections, dwarf the value of the equipment and even the real estate, if there is some. So the takeaway is use a concept you may already be using, but apply it to other assets. Now let's talk about cash flow protection. This may be something that's on the mind of physicians even more than their assets, is the cash flow. And I can understand that. And we could spend a whole other hour on all the different tools that you could use to save taxes and dig down very deep. I'll spend 5 to 10 minutes right now on that. Essentially, the best tool for protecting cash flow is a qualified retirement plan and other benefit plans. Okay? We'll dig down into that in a slide or two. Those can provide, on qualified plans, in almost all states, the highest level of protection, +5 level of protection. On fringe benefit plans, they range, depending on your state, between +2, again, which is solid, to +5, which is off the table. And there are even other fringe benefit plans that may be much smaller in terms of dollar value, but that can also protect the assets. So let's look specifically at qualified retirement plans. And qualified retirement plans mean 401k, pension, profit sharing plan, etc. IRAs are similar. We'll talk about that in a second. Okay? But they work tax-wise the same, SEP IRAs. Okay? The good news about qualified plans is on the asset protection side, which is that they are exempt under federal law. Federal law applies to every state. And almost every state protects them at the same high level of protection. Okay? So in all of physicians I've seen, typically one of the assets in their +5 category is their qualified retirement plan. Okay? If you're a solo practice and you have very few or no employees, then we really got to make sure the qualified plan documents say what they're supposed to say to get that high level of protection. In some states, you may not have it if you're just the only participant. Okay? If you're part of a practice that has 5, 10, 20, 30 employees, you're definitely going to have that level of protection in that document. Okay? So that's the good news. The good news is on the asset protection side. Again, this isn't a tax lecture, but I do want to make the point that there are some negatives to qualified plans, and this is why other tools may round out a full asset protection plan on the cash flow at the practice. One is that you have to cover all your employees. Very strict rules when you're using qualified retirement plan on what you have to offer to employees. And I've seen, unfortunately, a lot of physicians stop using their qualified plan when they own their own practice because of the cost for employees. So it is important. Okay? The second thing is taxation. And we know we get the full deduction going in, but the negative to qualified retirement plans is we're going to pay income tax, full income tax, on whatever the tax rates are in the future when we pull it out. Okay? I use my father as an example. He had dollars contributed to his qualified retirement plan when he was practicing radiology in New England. Now he's retired, semi-retired, actually still practices. And when he was practicing in the 1970s, the tax rates, marginal tax rates, were well above 70%. So he got a deduction at 70%. Now he's in a state, Florida has no state income tax, so when he pulls those dollars out, he'll pay only a maximum of 35. That's a good leverage. Get a deduction at 70, take it out at 35. Today, we know we're at the 35 bracket. It may be going up. As you hear this in 2013, that rate may have gone up. But whatever it is, 2012, 13, 14, relatively we're at a low tax bracket, as we'll see in the next slide. So we just have to understand that the tool of a qualified plan, terrific for asset protection, but it is essentially a bet that tax rates stay about the same or go down in the future. If we believe that tax rates would go up significantly in the future, we might do some other benefit plans that are better positioned and still have high levels of asset protection. So qualified plans are very solid, but you got to understand all the bells and whistles around them, just like you would with a medicine, prescribing it to a patient. It may be very good for asset protection, but it doesn't mean necessarily you should put all your eggs in that basket because of some of the other bells and whistles that come along with that medicine. So this slide, we can see the top marginal bracket of the federal rate only, and many of you are in states that have state income taxes on top of this, basically since 1914 when the federal income tax was enacted. You can see for most of the 20th century, the highest rates were well above 60%. In fact, in some years, well above 80%. Now, since the Reagan Revolution, it's come down in the 30s and 40s, and now we're actually at the third lowest place we've ever been. Relatively, as we're talking about this in terms of the qualified retirement plan, we don't know what rates will be in 10, 20, 30 years. But I think you can look at this chart and say it's certainly a possibility that rates go back up, maybe not to as high as they used to be, but somewhere above the levels they have been for the last decade or two. And so the qualified plan, while it might provide terrific asset protection, no one likes to use a tool that provides great asset protection but costs you a lot in taxes. We know taxes are due every year and every quarter for those of us who pay quarterly. Lawsuits are potential. So again, it's a balancing act. I have a qualified plan. Frankly, I haven't put a lot of dollars into it for the last couple of years because of this issue. But I do have a fair amount in my qualified plan, and I know that's very well protected. I do use other plans in addition to that, which can provide me a level of asset protection that is high, and also give me a little bit of a tax hedge. But before we talk about that, I want to make one comment about IRAs, because many of you may have IRAs, and they work similarly to qualified plans. IRAs, again, are protected at the federal level, okay? And state law, however, unlike qualified retirement plans, is much more across the board. For example, one state I know very well is California. In California, IRAs are only protected to what's reasonably necessary for support. You might say, hey, that sounds like a pretty good standard. It's reasonably protected. But really what that means is it's up to a court to decide how much a physician's IRA should be protected. And they're going to look at a standard for the average Californian who probably has, $10,000 to $50,000 in total retirement savings in IRAs. If you're a physician who has $500,000 in retirement savings in IRAs when you're about to retire, and you have a lawsuit against you, and you're relying on the asset protection of California law, you may be in for a very bad surprise when the judge says, yes, it's protected, but we think what's reasonable is $50,000, and the other $450,000 can go to the creditor. So we don't see that as very high level of protection in states that have that kind of language. And sometimes it may make sense, actually, I've recommended this for many clients, in states where you have that discrepancy between the IRA protection and the qualified plan protection, is to actually roll the IRA into the qualified retirement plan. So I've told doctors, let's say who have their own practice, small practice, create a qualified retirement plan. You can even make it has small contributions, so it's not going to cost you a lot for employees. Take your IRA, if it's eligible, and roll it into that plan. That way you're actually protecting it at a higher level. Or the opposite, now you're thinking about retiring, doc, but you're in a state or you're going to a state that doesn't have a high level of protection for IRAs. Don't roll it out of the qualified plan. Keep it in there and still enjoy that high level of protection. That may apply to some of you. So I mentioned other benefit plans. What else could you do to protect cash flow that is not a qualified plan? Again, I could do a whole lecture on all different fringe benefit plans. There is one under a particular code section, 79 of the tax code, that provides a high level of protection. In about 20 of the states, the protection is at the +5 highest level. And at the other 30 states, you can create it inside of a trust or LLC and get to probably the +3 level of protection, +2, a very solid level. And the way this plan works, I don't have time to go through all of it, but it essentially works as the opposite of the qualified plan. You pay some of your tax today. So again, you still get some tax leverage today, but it grows tax-free, and if properly managed, it comes out tax-free in retirement. So unlike the qualified plan, that is a hedge. Essentially, you're hoping that tax rates don't go up a lot. This plan is a hedge against that, essentially, because no matter what tax rates go in the future, this plan will not be taxed when you take money out. So it's similar, if some of you are familiar with Roth IRAs, but the difference when you put money in a Roth IRA, you pay 100% tax going in. Here, you're only going to pay a tax according to the IRS formula, and it depends, slightly different for everybody, but let's say, assume about 60 to 65% will be taxed. The rest of it will escape tax. So you get the tax benefit up front, partial, full tax on growth, full tax benefit, no taxation on growth, and then no tax on withdrawal. But what we're talking about today is asset protection. So it can have tremendous asset protection. Here's another type of tool that, again, can be done for asset protection planning, but at the end of the day may save you $5,000, $10,000, $15,000, $20,000 a year, depending on your contribution, in taxes every year. So I have plenty of clients I've worked with over the years who've said, Dave, I'm glad you set up this asset protection plan for me. But in the end, I didn't really need it. I never was sued or had a couple lawsuits or claims, but they were dismissed. What I really like was the plans you put in place helped me save over these years $50,000 in taxes, or helped me create an extra $100,000, $200,000 of retirement wealth for my retirement. And that's why qualified plans, non-qualified plans, fringe benefit plans are so valuable, because the asset protection is important. That's the point of the lecture today. But at the end of the day, you may value the wealth creation and the tax savings as much as the protection. So I call this plan kind of a hybrid benefit plan. Because it combines the elements of a qualified plan, the high level of protection in many states, and a significant level in other states, with a non-qualified plan in that it doesn't have the full taxation on withdrawal. There are other benefits as well, which is one is you don't have to offer to all your employees. You can carve out a group, and even if you're in a small practice where you don't have enough people for a group, the cost for employee participation, because it's a fringe benefit plan, is much less than a qualified plan. So as employers, if you're a physician who owns your own practice, we're always looking at the bottom line. And if you can put in a plan that provides the asset protection we've been talking about, has some of this beneficial tax treatment, and also have lower employee costs. And finally, not all physicians have to participate in it, which is another big benefit if you're in a group. Fringe benefit plans, I could decide to do it, my partner could not. That's a big benefit. Qualified plans sometimes don't have that kind of participation election. So a lot of reasons to look at that as part of your asset protection, tax, and benefit planning package at the practice. Another tool I must mention just for a minute or two is a captive insurance company. Captive insurance company is just what it sounds. You own your own insurance company. And for practices that are significant in revenues, probably $5 million or more, so very successful small group practices or larger group practices, this can be a very important tool. Generally, it's not there to provide protection on the malpractice insurance, but a lot of other types of insurance that you probably don't have coverage for today. Things like sexual harassment defense and wrongful termination defense, or a Medicare audit defense. A whole host of risks that today you hope don't happen, but you don't really have any coverage for it. Well, if you had an insurance company that you owned to provide that coverage, not only would you have it if you needed it, but if you never needed it, the IRS and Congress gives us some significant tax benefits for setting up that type of arrangement. So again, it's one of those tools that can provide tremendous asset protection for you if you ever need it. But if you don't need it, you're still going to enjoy tremendous tax benefits. In fact, the clients, the few that we've got who have set up captives or with other law firms, oftentimes, again, they've used it when they've needed it for claims. But if they have minimal claims or they have no claims over time, the wealth creation, the tax benefits, the ability to have it tie into also their buyout of physicians who are leaving the practice, recruiting of physicians coming into the practice, a lot of different business and tax and wealth reasons to have that tool in addition to the asset protection, even though they may have come to the idea initially for protection purposes. If we look at this slide, you can essentially see how it works. The captive is providing coverage. The practice is paying premiums just like it would to any other type of insurance company. But the difference here is that the owners of that insurance company are the physicians themselves, or in some cases can be physician families, trusts for the physicians, etc. And it's an advanced tool. If you're interested in learning more, we're happy to chat with you about that. The basic benefits of the captive, as I mentioned, it's a great asset protector because it provides some risk management. And the captive assets itself can be protected at the highest level, especially if the captive itself is owned by trusts for the physicians. So not only are you getting some tax benefits of the dollars flowing out of the practice, not only are you providing risk management for the practice by giving them coverage it didn't have before, but the assets inside of the captive are growing in a terrific asset protected environment. Minimally +3 or 4, with the right type of trust in place, a +5. So you really can have your cake and eat it too to some degree. Get good coverage on things you don't have coverage for today, get tremendous tax benefits, and also significant asset protection along the way. Now let's spend a couple of minutes as we get to sort of the back end here on personal planning. Now, just because we're at the back end doesn't mean it's not important, because in fact, most physicians, when they think about asset protection planning, think about protecting their personal assets. My home, my investments, things I've saved. And that's, of course, important. We're not going to get the same kind of tax benefits as we're going to get with the tools at the practice level, like the qualified plans, like the non-qualified plans, fringe benefit plans, captives, et cetera. When we're looking at protecting personal assets, it's really about taking an asset that might be owned by me, might be owned jointly with a spouse, and trying to get it at a better level of protection. First, let's start with exempt assets. And we always start there for one important reason. It's the best level of protection. So why not start with the top level? Then we can look at tools that fill in where the top level can't be achieved. And the reason we can't achieve it with all assets is that we're limited in what the state gives us and what the federal government gives us. The federal government, as I mentioned, protects qualified plans and IRAs at the highest level. That's it in terms of federal exemptions. So really what we're getting when we're talking about personal exemptions is what's in the state, and that varies terrifically. Some states provide a total protection for homestead. You can have a $5 million house. You can have a $10 million house. You can have LeBron James' $50 million house in South Beach. Okay? I think it's actually Coconut Grove. But in Florida, homestead is exempt to an unlimited value. There's some geographic limitations of how large it can be, so I don't know if LeBron's home is actually covered. But in Florida, you can have a $20 million home, and if it comes within the geographic limitations, you can file for bankruptcy, you can have a lawsuit against you of any number, and it can't be touched. If I look at another state like New Jersey, has no homestead protection. You have $10,000 of value in your home, and that's it. It can be taken in a lawsuit. So you can see the wide range. It really depends on your state, and I would really encourage you to contact us to learn more about what the rules are in your state. But we want to start with that because, as we'll talk about in the homestead protection, but there are other protections that state exemptions can give us. Some states provide a tremendous protection for cash value life insurance. And we could do a whole lecture on that. Some states provide a whole benefit, entire protection for annuities. Some states provide protection, as I mentioned before, for assets in a spouse's name. Others don't protect it at all. So it's very state specific on the exemptions, and we try to figure out what are the exemptions in your state. Let's maximize the use of that, and then we can turn to other tools. LLCs and FLPs, limited liability companies and family limited partnerships. The reason we use these tools so often is a couple reasons. One is you can maintain control. You can be the managing member of the LLC, the general partner of the limited partnership, and maintain control of the asset throughout, yet still have a high level of protection. Okay? Two is they're typically set up as partnerships, certainly a partnership would, but also LLC, so they're tax neutral. You're not going to pay any more in taxes. Third, they can own almost any asset. I have clients who have LLCs that own their investment accounts, that own artwork, that own jewelry, that own stock and family businesses, that own intellectual property. Almost any asset you can possibly own personally, you can own inside these. So you can maintain control, doesn't cost you any more in taxes, and any asset can go in there. That's why they're so valuable. And they're not expensive to set up. So because of this, it's very important. Now, how do these tools protect assets? Well, let's give an example of me. Let's say I get into a car accident and I have a $100,000 investment portfolio. And they come after me and they sue me. If I own that portfolio in my own name, it's -5. It can be taken. If I own it jointly with my spouse, in most states, half of it is vulnerable. So they have a judgment against me, they can take half. But if I own that same investment portfolio inside of an LLC or a limited partnership, they can't get to it. That's called an outside creditor. They cannot get inside and get to that asset. They may have some small rights to wait and see if there's a distribution, as we'll talk about in the next slide, but they don't have any rights to get in there if it's done right. Again, a lot of times I see physicians who bring me limited partnerships or LLCs and it's not done right. The language isn't right, hasn't been formed right. So you got to do it right just like any procedure or any medicine. You got to follow the directions. Okay. These tools are also valuable, especially LLCs, for inside protection. So let's say instead of the car accident, I own a piece of rental property. If I own it in my own name and there's a problem with the renters, they can sue me personally and take all my personal assets because I'm the one who owns the rental property. But if I own that property in an LLC and it's done properly, they can only sue the LLC. They cannot come after any of my personal assets, even though I own the LLC. That's an LLC used for inside creditors and inside protection. Keeps the isolation of the problem inside the end. So let's dig a little deeper into outside protection, because I think that's what most physicians are concerned about, being sued for malpractice, being sued for something at the practice or a car accident, et cetera, and how do limited partnerships or LLCs, which are such valuable tools, protect those assets. On this slide, we have what are called basically a graphical description of the charging order rules. And the charging order rules, if you've ever heard of it, or if you read it in our book or any of our materials, is really the basis of what protects assets inside of limited liability companies and limited partnerships from outside creditors. Going back to the example, if I get into a car accident and someone sues me and wants to get at a portfolio, if I own it in an LLC or a limited partnership, or someone's suing you for malpractice and they want to get to your investment portfolio, what protects the asset inside of an LLC or limited partnership are the charging order rules. And what this slide tries to show you is that if you set this up right, they only can get what is called a charging order. They cannot get inside to the partnership or the LLC and get at the investment assets. They cannot become a member or a partner in the partnership. They cannot get voting rights. They get no control of the asset. You can decide to sell that stock and buy a new one, et cetera, et cetera. You have control. You maintain that. They don't get any way to get inside. But what they can get at what's called a charging order, which allows them to get a distribution. Okay? That means if you decide, as the managing member or general partner, to make a distribution from the entity to your name, they can step into your shoes and take that distribution. It's called a distributive right. So they have some rights, and this is why using LLCs and limited partnerships are a +2 level of protection. They can sit outside with that charging order and say, listen, I filed a charging order, you owe me this money, and I'm going to sit there, and if you try to take any money out of that partnership or LLC, I'm going to be able to take that. And they'd be right in that, okay? And that's a significant right, but you can come back to them and say, well, I'm just going to keep the assets there for years, and you're not going to get anything until I decide you're going to get something. And that's true also. And the kind of lawsuits you're concerned about, malpractice, car accident, the kind of lawsuits I'm concerned about are typically contingency fee type cases where the lawyer is paid only a piece of what they bring in. They're not billing hourly. So they have a real incentive to take some money today and move on. And if we're talking about protecting these assets when you've got insurance and other things that they may get some judgment for, the likelihood is you're going to be able to negotiate a really favorable settlement, 5, 10, 15 cents on the dollar, and move on. That's why these tools are considered +2 levels of protection. They're not +5, because remember, if I had that investment portfolio inside of an exempt asset, like a life insurance policy or an annuity in the state of Florida where I live, there is no negotiation. That's +5. They have no rights. I can get rid of them, and they can't get a dime of that asset. It's +5. But I can't put all my assets in a +5, so these are tools that certainly are better than owning it in your own name, because remember, at -5, if I own that asset in my own name, they wouldn't be negotiating, they wouldn't be putting in charging order, they'd just put a levy on my account and they would take it. So hopefully you can see a little bit, and certainly there's more in the books, about how charging order works and why they are considered a +2 level of protection, very solid, not as good as +5, but certainly a whole lot better than owning it in your own name like a -5. The keys to the protection, like anything, doing it right, just like taking medicine, just like doing a surgical procedure. You got to make sure the agreements are drafted right, you comply with the agreements, et cetera. And this is why it's so important to work with an attorney who has experience in doing this. Now I want to talk about protecting the home, one of the significant assets of every physician typically. And I mentioned before that LLCs and limited partnerships can own almost any asset. And they can technically own your home, but there are tax reasons why you probably don't want to do that. In fact, there are many asset protection attorneys around the country who say even if there were no tax negatives to doing it, I'm not comfortable putting an asset that has no real profit motive, like an investment portfolio, like a piece of artwork or jewelry or anything else that really is bought to appreciate in value. The home, while you hope it does appreciate in value, it's really a personal asset that you're living in. And there are attorneys out there who would say, I don't feel comfortable putting a home in an LLC or a limited partnership. Regardless, the main way most clients protect their home is through the homestead, or at least they take advantage of it as much as they can. Again, as I mentioned before, homestead varies from unlimited to zero, and there's everything in between depending on your state. So you got to find out in your state how it's protected. I also mentioned before that in Ohio, in the state that we wrote one of our books in, the rule is that you can own it in the spouse's name and still protect it. And that may be true in some other states. There are still other states that have an ownership form called tenancy by the entirety, where you can own it in a married couple's name, tenancy by the entirety, and you can protect it against claims of both spouses. So the home is a tricky one. You really have to see it from your personal state point of view. And oftentimes what you want to do is just keep enough equity in the home to take advantage of the homestead exemption. And that goes beyond the scope of this lecture, but the idea is if you're in a state where protection is great, then you put more dollars in your home. If you're in a state where homestead is not very well protected, then you try to limit how much you have equity in your home. You don't pay down your home aggressively. You put that extra cash somewhere else. With non-home real estate, it's much different. We don't have any of the reasons not to put a non-home, second home, rental real estate, etc., in an LLC. So for second homes, for rental real estate, for raw land, etc., limited liability companies are the tool of choice. We have clients who have many properties, and almost all of them are in LLCs. Now, are they all in one LLC, or do they split them up into multiple LLCs? Not all eggs in one basket. There's really a cost-benefit analysis. Now, how much is it going to cost me to do more LLCs, and how much equity are we talking about in those properties? But the tool of choice for non-home real estate is the LLC. So if you have second homes, if you've got rental property, if you've got investment property, and they're not in LLCs, if they're in your own name, it should be something you highly consider to look at putting those properties into either one or potentially a series of LLCs. So we've come to about the end of the hour, and I hope you've learned a fair amount. I've enjoyed giving you this information. As you've seen, I've covered topics that are legal tools. We've talked about exempt assets like insurance and annuities. We've talked about debt shields and not building up a lot of equity in homes if you're in a homestead state that's poor. We've talked about tax implications, qualified plans, fringe benefit plans, etc. Pretty multidisciplinary and covering a lot of ground. And as you've seen, a lot of this depends on the state you're in. So this is a good primer, and hopefully you've got some ideas, you've jotted down some notes, and you're thinking about ideas that might apply to you as you go back to your practice. We encourage you to continue the education. As I mentioned before, we're willing to give all of you who are attendees at AEI seminars a free copy of our book, whether that be the hard copy form or the e-form. You can see here on the slide my email, our phone number. Certainly contact us if you have more questions. I'm happy to chat with any of you. And learn more. We have a free newsletter on our website as well, where you'll go to get the book at www.ojmgroup.com. Learn more, see what applies to your situation, and hopefully in the next year you can put yourself in a better protected situation, both at the practice and with your personal assets. Thank you.
That concludes another in a continuing series of programs on medical malpractice, risk management, healthcare law, practice management, and selected clinical topics. Presenting was attorney David Mandell.